Members, welcome to today's meeting. This is the appointed time. We have a quorum. So I call this meeting to order. Item 1 on the agenda. Information paper issued since the meeting on the 2nd of June, 2026. The Secretariat issued an information paper on international organizations, privileges and immunities, the International Criminal Police Organization 231st Executive Committee session, and the 94th General Assembly session order provided by the administration on the 26th of June. This involves a legislative proposal in relation to a subsidiary legislation as at the end of the notice period, 5 p.m., the 2nd of July. The Secretariat has not received notice from any member to discuss the paper. All right, next item. The administration plans to submit the relevant subsidiary legislation in October 2026 for negative vetting process. All right, if there are no other issues, let's move on to the next item. Items for discussion at the next meeting. The next regular meeting is scheduled for the 6th of October, 2:30 p.m. The Security Bureau has proposed to discuss 2 items. First, publicity, promotion, and education efforts relating to national security, item 1 on the agenda. And then second, smart customs, enhance efficiency of cross-boundary customs clearance, item 2 on the list of outstanding items. Members, any views on the proposed items for discussion? Nothing? Thank you. Item 3, improving the laws on sexual offences in Hong Kong. This is a legislative proposal. All members have been informed, and they are welcome to take part in the discussion. Let me welcome Mr. P.K. Tang, Secretary for Security, and his team to our meeting. I will invite the Secretary to walk us through the paper. Members, if you want to speak, please press the button now. I'll give the floor to Mr. Tang. Thank you. Chairman, at present, sexual offences in Hong Kong can be found in the Crimes Ordinance. These offences are mainly set out based on similar ones in the English legislation that can be dated back to 1956. That's more than 70 years ago. Since the enactment of offences, there have been more and more concerns about vulnerable groups, including children and persons with mental impairment, and that they should be protected from sexual abuse and exploitation, and at the same time there should be respect for sexual autonomy. Although other common law jurisdictions have taken forward reforms on sexual offences, we have yet to revamp our laws in Hong Kong. And we also notice inadequacies in the provisions on sexual offences. For example, some provisions lack clarity and certainty, some offences are gender-specific, and some provisions lack consistency on treatments across genders. Some of the sexual offences are not given the same level of penalty to show the gravity of the relevant acts, and some of the terminology used are outdated. Against this backdrop, the government considers it necessary to review and improve the laws on sexual offences in Hong Kong so as to address the current inadequacies. On the other hand, the Law Reform Commission set up a subcommittee in 2006 to review the law on sexual offences and the related offences. After the full review on sexual offences between 2012 and 2022, 4 consultation papers were published. During the consultation process, there was overwhelming support for reform. The LRC later on published 2 reports in 2019 and 2022, respectively, with 72 recommendations. On the whole, the administration supports the LRC's recommendations. We have been actively following up on the recommendations in the 2 reports. At the same time, we also give regard to the relevant developments in other common law jurisdictions in order to set out the legislative amendment proposals. We also have regard to the LRC guiding principles to make sure that in terms of different sexual offences of different nature and gravity, we can ensure consistency in the reform process. The guiding principles as recommended include clarity of the law, respect for sexual autonomy, protective principle, gender neutrality, avoidance of distinctions based on sexual orientation, and also adherence to the Basic Law, the Hong Kong Bill of Rights Ordinance, and the ICCPR 6 points. To achieve the policy objectives on the basis of the LRC's recommendations and having regard to the relevant legislative developments in other major common law jurisdictions, we have come up with a range of legislative amendment proposals covering the following areas. 1. Non-consensual sexual offences. Under this headline, we set out the provisions for key legal concepts such as consent. We define the scope and withdrawal of consent. We also set out circumstances where a victim does not consent in the law so as to provide greater clarity. We also propose to widen the scope of the offence of rape. We propose to create 3 new non-consensual sexual offences, including 2 offences of sexual assault, and that is 1 without touching and 1 with touching, as well as causing a person to engage in sexual act without consent, so as to prevent anyone from causing another person to engage in a sexual act without consent. These recommendations, when implemented, can ensure greater clarity. It will offer greater protection to the public. We will also respect the principle of sexual autonomy. The second area is sexual offences involving children. We believe that the age of consent should be pitched at 16 years of age across the board, and if anyone has sexual intercourse with a minor under the age of 16, the person will be prosecuted. We also set out 4 new offences applicable to children specifically, and that is sexual penetration involving a children below the age of 16, as well as 2 sexual assault offences with and without touching involving children, as well as causing or inciting the children to engage in a sexual act. We also want to protect vulnerable groups. The first offense is to engage in a sexual act in the presence of a child, and also causing a child under the age of 16 to look at the sexual image, see or hear sexual written verbal communication, or causing a child to send a sexual image or communication. We also want to prevent, as early as possible, sexual exploitation of children. So we are going to propose 2 new offences, and that is sexual grooming of a child and also arranging or facilitating the commission of a child sexual offence, so that we can intervene early and take action in a preemptive manner in order to catch the perpetrator of these child sexual offences. We believe that these sexual offences proposed in relation to children will be able to protect children from pedophiles. The third area is sexual offences involving PMIs. At the moment, the law provides protection to people with severe mental incapacity to the extent that the impairment makes the person totally incapacitated. The law does not protect those with lower degree of mental impairment. So we're going to amend the law so that we protect persons with severe mental impairment to the extent of incapacity, called PSMI, as well as allowing PMIs with a certain degree of capacity to have sexual autonomy. Under the protective principle, for those incapacitated, there should not be any sexual activity because of the lack of consent. Any sexual act performed on PSMIs should be prohibited. At the same time, for PMIs who have a lower degree of mental impairment, they have the capacity of consent and their sexual autonomy should be respected. To adhere to the protective principles, we propose to set out the following new offences to target the sexual exploitation because of their mental condition. The first one is inducing, threatening, or deceiving such persons to engage in the sexual act. And the second sexual offense involves the offender who is in a relationship of care with a PMI or abuses a position of trust, authority, or a relationship of dependency with the latter and sexually abuses the PMI. And there are 4 such non-consensual sexual offenses targeting PMIs. This is the second area involving vulnerable groups. We propose a total of 18 targeted offenses for different level or persons with different levels of mental impairment. Our proposed offenses could cover more persons with mental impairment to different extents, whilst offering them protection. We also respect sexual autonomy in some cases. I want to stress that for offences involving PMIs in children, they carry extraterritorial effect so that we can offer better protection to PMIs. The 4th area is miscellaneous sexual offences. There are 7 proposals, including expanding the coverage of the offence of incest, and also creating a new offense of sexual exposure, sexual penetration of an animal, sexual act with a dead person, as well as administering substance for sexual purposes, etc. And we will continue to adopt the gender neutrality principle. The 5th area relates to strengthening protection for victims of sexual offenses. We will put forward a number of legislative amendments so that we offer greater protection to victims of sexual offenses, including gender neutrality, sexual autonomy, as well as measures to protect personal privacy, and measures to protect vulnerable groups, and also measures to strengthen protection of victims in virus-related cases, and also for these sexual offences to carry extraterritorial effect so as to provide more comprehensive protection to victims of sexual offences. Chairman, the government attaches great importance to the well-being of children, PMIs, and the general public. We're committed to protecting them from sexual exploitation and abuse. This is the original intent of the government in enacting sexual offences. Whilst comprehensively reviewing the laws on sexual offences in Hong Kong, we need to consider sensitive and controversial issues. We need to consider everything in a careful and comprehensive manner. We also need to listen to views of the public, of course. That is why we're going to roll out a 1-month public consultation. We welcome views on our proposal. At the end of the consultation period, we're going to collate and analyze all the views received. And then within this year, we propose to submit the bill to Legislative Council for scrutiny with a view to completing the legislative process within this term of government. We want to improve our laws on sexual offences as quickly as possible so as to enhance protection for victims and for Hong Kong laws to be kept abreast with the times. I welcome views and questions from members. Thank you. Thank you, Mr. Tang. 17 members, starting with Chen Hock-Fong, Deputy Chair, Dennis Leung, Ken Wong, Andrew Fan, Nixie Lam, Chris Ib, Chen Yong, Lau Ka-Kang, Eric Yim, Carmen Khan, Elizabeth Quat, Lau Chi Pang, Jimmy Grace Chan, Thomas So, Reverend Peter Kuhn, and Bill Tang. 17 members. I'll give each member 3 minutes, and let's see if we can do a second round. Mr. Chen Hock-Fong, Deputy Chair, will kick off now. Thank you, Chair. I think that we have been craning our necks for this legislative amendment, be it gender, sexual orientation, age of consent. I see a basket of legislative amendments. I support them. I hope that the Security Bureau will table the bill into the Council as quickly as possible. Now, I have a question. you're going to amend the definition of consent and non-consensual acts. In some cases that I came across in the past, there might be religious rituals performed and that involved sexual intercourse in a deceptive manner for, say, the change of luck. Will the legislative amendments be able to plug this loophole and address the issue? If somebody incites another person to perform the acts I mentioned in another place outside of Hong Kong, is there a way to catch them? Because the act is not performed in Hong Kong. Is there any way to protect our citizens?
Secretary, in our legislative proposal, we have listed out 11 circumstances in which sexual acts are considered as non-consensual. And in such cases, defendants will have to prove that this is consensual. We want to tighten the definition of consent because we want to prevent cases in which sexual acts or sexual assault are conducted under the guise of religious rituals. So one of the major purposes for the legislative proposal is to prevent victims from falling into prey in such cases. As to whether there is extraterritorial effect, well, as long as the sexual act is conducted in Hong Kong, or if the sexual act is conducted overseas, there will be extraterritorial effect. So we will have jurisdiction regardless of where the induction or the sexual offenses take place. I'd like to clarify. By luring somebody to have sex, does that mean you have to first lure someone to travel overseas? Well, someone may ask you to travel abroad and lure you into having sex, and that could be considered as an offense. So for both circumstances, there will be extraterritorial effect. Next, Mr. Dennis Leung. I thank the government's efforts in trying to improve the laws on sexual offenses. I hope that we will get views during the one-month public consultation. I think starting from this moment, we should do more on education. There is sex education for primary school students. However, for both primary, secondary, as well as university students, I think there is a lack of education on sexual offenses. I think we need to do more in order to ensure good implementation of the laws. I have a couple of questions. There is a term known as sexual penetration in the legislative proposal. Does that mean penile penetration? If a certain type of tool is used, and if a false penis is used in the penetration, would that be covered under sexual penetration, or would that be regarded as indecent assault? Second, I see that for the age of consent, in the past, there were offenses involving or covering girls aged 13 or 16 below, but the administration is now proposing a uniform age of 16 for consent. And that would apply to other crimes such as burglary. In the past, there were cases of sexual offenses that involve step-parents? And in future, would that be regarded as buggery or rape? Please clarify. Secretary. Let me respond to the point about sex education. There will be cross-departmental efforts. For example, the Education Bureau, the Social Welfare Department, as well as the police force have been involved in sex education. About penetration, in the past, when we define rape, we just defined it as penile penetration by men into women's vagina. However, there could also be cases in which there is penetration into anus, and we think that in these cases they should be regarded as rape. For offenses in which tools apart from genitals are used to penetrate into women's vagina will be regarded as rape. To address the point about uniform age of consent, in the past, the penalties were different for cases involving children of different ages. However, the penalty is now made uniform. And for children aged below 16, we assume that they do not have the capacity to give consent to sexual act. Also, for incest, in the past, such cases may only involve parents, but adoptive parents were not included. Now we adopt the concept in marriage ordinance. As long as it is stated in the law that you cannot get married with that person, and if you have sex with that person, it would be regarded as an offense. Assuming that there is a case involving a child aged below 16, it will not just be incest, but also rape. Next, Mr. Ken Wong. I support the proposal to improve laws on sexual offenses. Currently, the relevant definitions and protection scope are very vague, and there are unclear distinctions for offenses involving people of different sexual orientation. The proposed laws will help create a deterrent effect, and I believe it will strengthen protection for victims. I have a couple of questions, and I speak on behalf of the education sector. Items 44 to 73 mention that there will be a uniform age of consent of 16, and there will be 8 dedicated measures to protect children, and there will be corresponding penalties for such offenses. For children aged between 13 and 16, if they are subject to non-consensual sexual act, what would be the relevant threshold for police caution? Paragraph 62 to 66. It is about a new offense for protecting those with mental impairment, and I want to know if there will be training for teachers or tutors in tutorial schools. And will the sexual conviction record check scheme be amended based on the new legislative proposal? Also, there have been a lot of internet-related sexual offenses. There are also people inducing minors to engage in sexual acts online. In relation to this, what kind of preventive work will the administration carry out at schools? Secretary, concerning age of consent, we assume that those aged below 16 will not be able to give consent. So regardless of your genders, if you engage in sexual act with a child aged below 16, then you would commit an offense of rape. There are cases in which sexual acts or sexual intercourses happen between two children aged between 13 and 16. In such cases, both parties would commit the offense of rape. However, there might be different scenarios. In cases in which a child have sexual intercourse with a stranger, of course that stranger would commit an offense. However, in cases in which both children aged 15 have sex and they get married, then we would exercise prosecutorial discretion. We've also adopted police caution or superintendent caution to deal with such cases. If it is proven that both parties consent to the sexual act and the parents of both parties agree, then we might adopt such approach. For cases involving people with mental impairment, we refer to position of trust. If those abuse position of trust in engaging sexual act, the penalty may be more serious. And if the case involves a person with mental impairment, the penalty will even be heavier. Currently, the sexual offense records checks scheme cover tutors of tutorial school as well as teachers. Now we are introducing a new offense. For example, grooming. There are people online inducing children to engage in sexual act. So we are introducing this new offense targeting those who try to groom children or lure children into conducting sexual act. Next, Mr. Andrew Fan. I support this proposal to improve the laws on sexual offenses, and I hope that the law could be enacted as early as possible. I have a few questions. First, the administration proposes the uniform age of consent of 16 years old. I support this. Targeting vulnerable groups, there will be new offenses. For those cases involving victims of aged below 13, the penalty will be 10 years of imprisonment. For those aged between 13 to 15, the penalty will be life imprisonment. Would 5 years not be deterrent enough for the penalty? Also, according to the consultation paper, the laws target mostly adults that commit sexual offenses against or to children aged below 16. If the case involves a person with mental impairment and the person or the victim is aged below 16, would there be a law targeting that as well? For offenses of incest, if parents knowingly or are aware that there is such a case but refuse to report to the police, will that be a crime? Currently, under the mandatory reporting mechanism, it only requires professionals to report the case, but it does not mandate parents or family members to report the case.
Thank you. On penalties, you mentioned sexual penetration involving a child under the age of 16. The maximum penalty is life imprisonment, so there is no difference. You also mentioned children below the age of 16, and then in the presence of that child, you engage in a sexual act, and also there is a minor, there's a difference between a child below the age of 13 and 16. In fact, we've raised the level of penalty in relation to these offences involving children below the age of 16 to that below the age of 13. So to take the second question, failure to report the case of incest. That depends on the extent of the crime, whether the person involved actually caused or incited such act. It may not be a case of aiding and abetting, but then this person might tell the victim, don't tell anyone about it, just shut up, it's useless. Then if you guide the child in such a way, then would you be committing the offense? That depends on whether we can apply other offenses such as preventing the course of justice or child abuse. So you mentioned this scenario, and I'd say that there are other pieces of legislation that can apply here. Ms. Nixie Lam. Thank you, Chair. I'm not a member of the security panel, but the Secretary must know that even in the last term, I already showed concern about sexual offences, especially in relation to mandatory registration of sexual offenders on the register, so as to enhance protection for the vulnerable groups and children. In fact, I've heard comments that there's a lack of clarity in the legal provisions, and there is also inconsistency in the level of penalties meted out, and that is why I fully support this legislative amendment. I have two questions. First, the summer holiday is approaching, and there will be a lot of orientation camps coming up. I'd like to know more about sexual offences with touching and also without touching, such as the spilling of liquid. That's one of the elements. Now, if the new law comes into effect, will we be able to stop such acts? Because we often hear about these activities at orientation camps. Female students will be asked to wear white T-shirts, and that they'll be splashed with liquid water or liquid that comes in a rather peculiar color. Is there a way to rein in such acts? And also for the definition of children in sexual offences, you will adopt a uniform age of consent of 16. But usually we call minors those below the age of 18. So in this legal context, when it comes to age of consent for sexual activities is pitched at 16, 17, they are after all secondary school students. And that for persons of authority, say teachers, social workers, coaches, there may be an emotional bond. They might believe that they are truly in love. In fact, there are many such examples in other places as well. So for those aged 16, 17, they reach the age of consent, but this is a gray area. Some teachers, some coaches might act in a misleading manner. They believe that they are truly in love. But for adults, they need to exercise judgment. They are not doing this act with the 16, 17-year-old with good intention. So we should follow up on it, because in other places, even if the child is 16 or even 17, they can still be victims of sexual assault. So I want to know whether there is a provision in the legislative amendment to address this gray area or the loophole here. Secretary, thank you. You mentioned orientation camps and students wearing white T-shirts being splashed and soaked. There is a proposed offense here, and that is sexual offense with involving touching. That involves the splashing or spilling of liquid or ejaculation of semen or saliva, urine. Of course, this should be done for sexual gratification. This is exactly what the OCAM activities are about. if this is a deliberate act to cause embarrassment to the female student, that is by spilling liquid or splashing the student with liquid, then this is how this offense will apply. About the age of consent, 16 or 18, we've looked at overseas examples. Even though we set the age of consent at 16, it doesn't mean that those between 16 and 18 will not be protected. In fact, in our legislative amendments, we have this offense that is causing another person to engage in a sexual act because of the person being in a position of trust or a person of authority. Like you mentioned in the example, that person could be a coach or a teacher, and that person abused the trust in order to cause the minor to engage in a sexual act, and that is against the law. This is actually rape. Next, Mr. Chris Ip. I thank the administration for putting forward this legislative amendment. I fully supported the crimes ordinance and the provisions were enacted 70 years ago. I'm concerned about paragraphs 29 to 34 of the consultation document. As mentioned by Ms. Nixie Lam, these are offences of sexual assault involving touching and without touching. For example, emitting saliva. How about two persons engaging in an argument and then somebody suddenly spits at the other person? Then will this person be committing sexual assault? Because for other bodily fluid, I can easily understand where they come from. But for spitting of saliva, how should I go about this? For sexual assault without touching, let's say if two persons are in a shouting match and they just hurl a lot of profanities involving the genitals to the other, then will the person be committing the sexual offense of sexual assault without touching? Now, about spitting, I emphasize that these acts must relate to sexual acts. If you just engage in an argument and you spit at each other, then there's no criminal element to speak of. Say, apparently, if you say something to this lady that you look so nice and then you then spit at her, then apparently it comes with a sexual purpose, so you could be breaching the law. And about sexual offenses without touching, and that is about shouting abuse. It's sexual assault without touching. This is the name of the offense. It carries two limbs. First, it must involve sex. Bickering does not count. Second, there should be apprehension of use of violence or threat of use of violence so as to cause the victim harm or distress or humiliation. I think this is clearly spelled out. Any follow-up? No? Next, Mr. Chan Yong. Thank you, Chair, Secretary, and the administration team. I thank the Secretary and the government for amending the legislation on sexual offences, because our society progresses on offering greater protection to the vulnerable groups, including women, children, and the disabled. Now, I'd like to go to paragraph 22 of the paper, and that is not sound just to regard the victim as having given consent because the victim succumbed to the force or the victim does not put up a fight. It may have to do with the traumatic response. And in the past, some offenders have cited this as a defense for mistaken belief of consent. I'd like to know more about that. Next, about paragraph 97 in page 42, say if somebody sends images of the genitalia to the victim online, then Does it fall within the scope of the offense? Will there be protection for the victim? Secretary. In our legislative amendments, we set out 11 scenarios of lack of consent. The first one is the victim does not communicate consent either verbally or through actions. So the victim does not indicate any consent. About the mistaken belief of consent, in fact, this is spelled out in the law. The defendant is obliged to make sure that there is consent. So if you're reckless as to whether the other side consents or not, then it's an offense. About sending dirty pictures on the internet, will it be an offense? In relation to a child under the age of 16, we have a new offense, and that is causing this child to view a sexual image or see or hear sexual written or verbal communication, etc., then this is an offense. So sending pictures of genitalia to a child, be it through the computer or otherwise, will be captured. Next, Mr. Lau Ka-Kang. Thank you, Chair. I welcome the administration's proposal to amend the legislation to address existing inadequacies and to cope with evolving changes of society's concept on sexual offences. Now, my questions are as follows. 53 persons were arrested for having sexual intercourse with mentally incapacitated persons between 2021 and 2025, but only 5 persons were ultimately convicted. As for coercing sexual acts, 98 persons were arrested, but only 1 person was successfully convicted. The conviction rate is so low. I want to know, after legislative amendments, whether the conviction rate will be increased. And about the stronger protection for victims, I fully support the proposal. But I have another suggestion. The sexual conviction record checks mechanism is a voluntary one. Even if we expand the scope of this check, we won't be able to stop hidden pedophiles. For high-risk professions such as home tutors, children's counselors, they spend a lot of time alone with the children. They may even exploit the trust of the children as well as their parents in committing the crimes. So we should turn this system into a mandatory one. We should make sure there is mandatory disclosure of previous sexual convictions. For pedophiles having committed serious offenses, they should be barred from taking up any jobs that can have access to children. Secretary, thank you. In relation to conviction of offenses involving MIPs, the conviction rate is low. This is because of the high threshold. We need to prove that the victim is incapacitated under this legal definition before we can proceed. So we have made a change. We want to lower the threshold to have better regard to reality. As for sexual convictions check, in fact, it has been implemented in different phases. We started with schools, and in fact now even private tutors and tutorial schools are covered. If you're not willing to be checked, you may not get hired. We have yet to turn it into a mandatory system because some school principals may be familiar with the system, or somebody might have committed an offense at a very young age and then turned anew, and he may be considered somebody of low risk. even for the teaching profession, there are different positions available. Some are of a lower risk, so we will keep this in view.
Dr. Eric Im. I support the administration in moving with the times to review the laws on sexual offences in Hong Kong. I have 3 questions. Pages 20 to 21 of the paper talks about offences involving those under 16. For adult women who have sex with boys aged below 16, would they be covered under the proposed laws? Page 38 of the paper. Laws on sexual offences involving people with mental impairment. If a person does not display symptoms of mental impairment and the perpetrator has no idea that the victim has mental impairment, will the perpetrator be caught? Page 42 of the paper. Sexual exposure will be regarded as a sexual offense. However, in some cases, the law offender has not even exposed his genitals. Say he is sitting in the library and he only puts his hands in his trousers without harassing or molesting anyone. Would this be covered under the law? Secretary, the first question. Say an adult woman has sex with a boy aged below 16. Currently, under the law, only men can rape a woman. After we revise the law, women can rape a man. Say an adult woman compels a boy under 16 to have sex with her, that would be rape. Now, turning to the point about people with mental impairment. In the past, there are known as persons with incapacitated persons. And now we refer to the Mental Health Ordinance. There are people with milder mental impairment. For those with serious impairment, they do not know what a sexual act is and they cannot decide whether to give consent to a sexual act. For those with serious mental impairment who cannot give consent, and if you have sex with these people, it would be a crime. As for those with relatively mild impairment, we need to respect their sexual autonomy, and if you have sex with them, it would not necessarily be a crime. However, as said, if you abuse your position as a carer or your position with authority and you compel a person to have sex with you, that would be a crime. The member just now asked or talked about a scenario that takes place in the library. It really depends on the behavior of the perpetrator. It could be molestation or harassment. However, if you engage an act with the intent to have sex with a victim, and if the victim truly believes that he or she could suffer from distress or humiliation, then it could be against the law. Ms. Carmen Khan. Chairman, I welcome this legislative amendment proposal. The purpose is clearly explained by the Secretary. Well, I'm particularly concerned about the measures to protect children from being sexually abused. I would like to ask about sexual grooming. We have seen relevant crimes recently, and I want to know how you define an offense of sexual grooming. Does that mean as long as the person has the intent to commit sexual grooming without completing the offense, he will be caught by the law? Also, would it be possible to prevent such offenses through decoy operations? Now, I'd like to ask about the definition of incest. The proposed amendment here is a little different from the recommendation made by the LRC. The LRC suggested covering adoptive parents, but the administration proposes a broader scope. I want to know how you will draw a line here. Of course, adoptive parents will be covered. What about a couple who adopt two children who are not related in blood? Will that be covered? Secretary. The member asked about sexual grooming. There are many pedophiles nowadays who get acquainted with children online, and after that, they use digital means to ask these children out with the intent to have sex or sexually abuse the children. Currently, we do not have any laws to prevent such crimes. Therefore, we propose to introduce a new offense of sexual grooming to prevent pedophiles from grooming children with the intention of sexually abusing them. There are sometimes decoy operations mounted by the police online. We will state it explicitly in the law if an undercover is mounting an investigation, then the undercover police could be exempted. As to where we are going to draw a line for incest, there are many arguments about whether you are step-parents or adoptive parents, so we made reference to the marriage ordinance. If it is allowed that the couple could get married, for example, step-parents or adoptive parents could not get married with you, and if there is incest, that would be against the law. Same applies to step-parents. So we draw reference from the marriage ordinance to decide whether an offense is regarded as incest. I think this is in line with the moral principle in Hong Kong. So please refer to the marriage ordinance. If you cannot get married with the victim, then it will be regarded as against the law. Ms. Elizabeth Kwok. In 2019, the LRC proposed reviewing the laws on sexual offenses in Hong Kong, and since then I've been calling for the government to revise the relevant legislations. So I welcome and support the proposed legislative amendments. I'd like to ask about page 10 of the paper. It says that victims may not give verbal consent to a sexual act. That means without the consent of the victim, it would be a crime if you have sex with the child or the victim. In some cases, the defendant says the victim follows the perpetrator to the hotel. That means it could be a hint of consent. However, our view is that following the perpetrator to the hotel does not mean the victim gives consent. So how should we interpret such act? Also, defendants may use honest but mistaken belief as a defense. The defendant admits that he engaged in sexual act, but then because the victim kissed the defendant mistakenly believes that he has the consent. So I want to know how we are going to interpret this defense of mistaken but honest belief. Also, page 14 of the paper talks about sexual assault without touching. I want to know, would that cover cyber thrashing? Say, a person exposes his private part online, would that be under the scope of the proposed amendment? There is also mention of sexual image in the consultation paper. Does that cover animation, cartoon, or AI-generated images? For images showing animals having sexual intercourses, would that be considered as a sexual image as well? Also, deepfake generated images are not covered in the proposal. Say, for example, someone uses secretary's image to generate a pornographic image. Would that be caught by the law? This is not mentioned in the paper, so I'd like to learn more about this. In the paper, we've listed out 11 circumstances in which consent is given. Of course, there are always different scenarios. To give you an example, someone follows you back to the hotel, but he or she does not say what he will do. And if the person gives you a nod, you may see it as a consent. So I think the defendant has the burden of proof. You have to ascertain that you have the consent of the victim to make sure that you have the consent. Also, kissing does not imply a consent. I think this is clear. Also, during a sexual activity, the victim could at any time withdraw the consent. For example, if the victim only agrees to protected sex, and if you withdraw the protection, you may immediately lose the consent of the victim. As to whether sexual exposure online would be considered as a sexual assault without touching, the answer is yes. This is because the victim may get distressed or humiliated because of this act, and this could be done online. As for sexual images involving real persons, as well as AI-generated images, they could be covered. Well, the secretary did not answer my question about deepfake generated images. Well, deepfake generated image such as animation, cartoon, or videos involving animals, as long as the videos or the images cause distress to the victim, that would be against the law. You said deepfake images will be covered, and that's understood. However, I create an image without showing the image to anyone, but I use your image to generate a pornographic image, and that image is kept in my computer, which may be viewed by other persons. And how would this situation be dealt with? Under the current law, if I publish such an image, it would be against the law. What if I keep the image to myself?
This may not be directly related to these sexual offences that we're discussing, but if you're in possession of these obscene articles, then this may be a breach of the law as well. even if you are not intentionally showing anyone, by possessing these obscene articles, you may be breaching the law. Professor Lau Chi-pang, I support the legislative amendment. I think we've discussed this item for a long time. And I have a feeling that many members here are still inquiring with the Secretary about a lot of provisions, for example, as to where the lines should be drawn, what constitutes a sexual offense. So I can't help but turn to the question of education. And I think that what we should have in mind is civilization, and that we need to educate the public. Sometimes a person might commit the same mistake repeatedly before finding out that it's actually wrong. So in this legislative amendment exercise, I want to make sure that public education is included so that people become more civilized. Of course, I fully support the legislative amendments. It's a question of how we explain to the public. I emphasize that by education, I don't mean what happens in classes in schools. I mean educating members of the public so that they are aware of the legislative amendments and that they now understand that certain behaviors are no longer tolerated in a civil society. Secretary, thank you. Chair, thank you, member, for what you said. Of course, apart from the legislative amendments, education is important. We need to have education in school, of course, but on top of that, we need to rely on families, social workers, and workplace. So I think, of course, we should consider mounting a publicity campaign for the legislative amendment exercise. Any follow-up? Yes, I welcome this response from the Secretary. But I want to know, in terms of a major publicity campaign, which bureau will be the lead bureau? Or will there be joint efforts from different parties? Now, as the member said, the publicity campaign will be conducted by the government as a whole. If no bureau wishes to take lead, then I, of course, don't mind taking the lead. Mr. Jimmy Ng. I support the legislative amendments. This is an improvement according to paragraph 71 of the paper. The sexual offences involving a child will carry extraterritorial effect so as to go after pedophiles who might fled Hong Kong. Now, but we do not have any law enforcement power outside of the territory. So what will be the arrangement? Will there be collaboration with another jurisdiction in, say, collecting evidence, searching for victims? Will assistance be provided? Will online hearing be possible? If the case happened in Thailand, for example, can we arrange a televised link for the witness to give evidence in Thailand so as to increase the conviction rate? Secretary, thank you. I've talked about the extraterritorial effect for sexual offences involving children. Let's say if I go on a trip with a child to Thailand and then I rape the child, and clearly it's against the law. Now, in the past, our laws did not carry extraterritorial effect. With the passage of this bill, there will be extraterritorial effect. That means we will be able to catch the perpetrator when he comes back to Hong Kong, or when they come back to Hong Kong. And of course, we need to collect evidence. For example, we need to check for video recording in a hotel, and we do rely on the Interpol and other collaboration mechanism with the police authorities or institutions in the other jurisdiction. As for televised link, it's possible for witness to give evidence in such a manner. In fact, this happened in the mainland and in another jurisdiction. If need be, such arrangements can be made. Any follow-up? Next, Ms. Grace Chan. I have a question for the Secretary. Mandatory of child report cases. The law now clearly defines a child as somebody below the age of 18, whereas here, for sexual offences, the age of consent is 16. Now, there seems to be a difference here. The Secretary just now explained that the same protection can be offered. I'd like to know why we cannot align the relevant age for, say, the offense of incest for the sake of protecting children. Because of asymmetry of power, some teenagers at the age of 16 or 17 may be subject to manipulation for prolonged periods of time. They may not be enjoying autonomy in giving consent. So do they get the same level of protection? Another scenario is that some victims of violent crimes, in fact 70% according to a study, show that they might freeze out of excessive fear. They might not be able to fight back or say anything, and that could be mistaken as giving consent. Is there any way for training to be provided to judicial officers and judges so that they understand this kind of traumatic response from victims of sexual violence to prevent them from secondary harm? About the age threshold, whether it be 18 or 16, for sexual offenses, we adopt this age of consent at 16 for child protection, whereas for other child protection provisions, we take the perspective of children's well-being. So things are different. That means 18 is the age to be adopted. Now, you mentioned teenagers between 16 and 18, and that they may be abused by a person in position of trust, say a sports coach, etc., and they may agree out of fear. And then after the legislative amendment, if this offense involves a person in a position of trust or authority, or if it involves a relationship of dependency, then no consent can be given. In the face of threat of use of violence, or in the face of violence, even if you're 16, 18, or 20, under such circumstances, your consent, the apparent consent doesn't work, and that it's still a crime. As for sexual violence and the response of the victims, we do work with the judiciary and the Department of Justice. If need be, we explain matters to the court. Next, Dr. Thomas So. Thank you, Chair. I support the legislative amendment. I also want to thank the Bureau for organizing the complex, colossal package of amendments for our easy understanding. I have some questions. First, about sexual assault without touching. I've read the provisions. I've also heard your answers to members' questions. I see overlapping between the proposed provisions and the current realm of sexual harassment. So, I think the administration should explain the provisions clearly to the public. That is, in the past, these acts might only be regarded as sexual harassment. Upon passage of the amendment bill, these acts could be regarded as criminal offenses. And I think you need to level with the public. Second point, for those below the age of 16, for example, childhood sweethearts. In fact, we came across this case about a month ago. The judge exercised, or the magistrate exercised discretion and released the defendant unconditionally, subject to a bond of good behavior. And the victim, as well as the defendant, were both 16 or 15 at the time of the offense. And yet they had to go through prosecution and the trial hearing. Of course, it's important that they be educated, that they reflect on themselves, and that for underage secondary students, if you engage in a sexual relationship, it could be criminal. But like the secretary said, the authority may exercise discretion and just give a superintendent's caution before closing the case. So, will you consider drawing up clearer guidelines to explain under what circumstances the police would most likely be dishing out a caution, and under what other circumstances would the defendant be prosecuted? Secretary, let me explain the offense of sexual assault without touching. There are two types: involving touching and without touching. Currently, the act constitutes the offense of indecent assault, but it is not very clear as far as the criminal elements are concerned. So we want to enhance clarity. Now, for offenses without touching, the first element is that it's sexual in nature. The second element is that the victim should be aware of such act, including the threats of violence, so as to cause humiliation, alarm, or distress of the victim. I just talked about sexual assaults involving touching. Now, for crimes of a lesser extent, the so-called sexual harassment, at the moment, these are not criminal offenses. These can be dealt with through administrative means. That is why we want to expand the criminal offense in the scope to capture these offenses and offer greater protection to victims. The other point is publicity. I fully agree that this should be done. Now, for the 16-year-olds, whether we should exercise police superintendent caution or initiate prosecution. In fact, even if in the case of superintendent caution, there is a supervision period. The teenagers would be subject to supervision by a social worker, by the police, and in fact there are clear guidelines, including the attitude of the victims, harm caused to society, and family support, etc. These are matters that the police would consider. Reference Peter Kuhn. I'd like to follow up on the offense of sexual assault without touching. I have a number of questions. First, it seems that in England and Scotland there are similar offenses. My first question is whether this offense is the unique offense to Hong Kong in the world. Second, about causing humiliation, alarm, or distress to the victim. This is a subjective matter. The maximum penalty is 10 years imprisonment. So in the scenario of sexual assault without touching, you need to spell out what scenarios this applies, because this may cause panic. Because for sexual assault involving touching, it's easy to understand. What if it doesn't involve touching, and if the victim feels alarmed, humiliated, or distressed? Then these are subjective feelings. It's hard to gauge, and that there may be a huge difference. So I'd like the administration to explain further, and please also elucidate on the level of penalty.
First, I'd like to explain the two offenses of sexual assault involving touching and without touching. Overseas, there are jurisdictions with such offenses. In Hong Kong, currently, we have the offenses of rape and indecent assault. And these offenses cover acts of sexual assault without touching. So we are proposing these two new offenses to protect victims. And therefore, one of the offense proposed is sexual assault without touching. And these two new proposed offenses, sexual assault involving touching and sexual assault without touching, are equivalent to rape and indecent assault. And these two offenses can clearly define under what circumstances a person commits an offense. And the member asked whether this lacks clarity. I believe that the provisions will be very clear. This is because we will include wording such as recklessness in the provision. And second, we have to make sure that the victim is subject to physical violence, causing the victim humiliation, alarm, or distress. If these elements are clearly stated in the future provisions, I believe the provisions will be clear enough. Any follow-up questions? I'd like to ask the Secretary, does that mean these two new offenses are only seen in Hong Kong? Well, there is such protection around the world. In some countries, the offense is still known as rape. It's just that we want to make it clearer. Rape could be very broad. It could involve sexual assault or indecent assault. Now we want to make it clearer. To give you an example, a member just now raised an example of university students spilling liquid onto others in orientation camp. Also, it was previously unclear whether cyber or internet-related crimes would be covered under the current offense. So by proposing these new offenses, we want to enhance clarity. Next, Mr. Bill Tang. Every year, the Social Welfare Department released figures or the number of cases involving children abuse. Children subject to sexual abuse is the highest number of cases involving children. And in these cases, it may not necessarily be their parents who commit the crime. Sometimes the crimes are committed by peers. I think the figures speak volume to the situation. Is the proposed legislative amendment intended to prevent cases we have recently seen that are carried out on social media? Also, I was the chairman of the Bills Committee on the Mandatory Reporting Bill. And there were clear definitions of what is regarded as serious assault. And that's Schedule 2 of the bill. If this is enacted as law, would that affect Schedule 2 of the bill on mandatory reporting? Also, I'd like to learn about the binding effect. In one case, a 15-year-old girl had sex with a sports coach and it was consensual. 10 years later, they broke up and the female decided to report the case to the police. Now we want to ensure gender equality. Will there be a situation in which after this law is enacted and a 15-year-old child has sex with an adult and 10 years later, because of the enactment of the law, the child reports the case to the police? Will this law have a retrospective effect? Secretary. Well, the reason why we propose the legislative amendments because we have seen an increasing number of cases recently. We are proposing to amend the definition of rape. That's one major point of the legislative proposal. Second, we want to strengthen protection for young children as well as those who have mental impairment. This is because there is an increasing number of cases involving these two vulnerable groups. Also, mandatory reporting can work hand in hand with the proposed legislative amendments. The mandatory reporting ordinance explicitly state what is regarded as a crime. For criminal cases under the mandatory reporting ordinance, cases have to be reported in order to safeguard children. However, for this particular legislative proposal, it will not have retrospective effect. Currently, under our law, only men can rape women. After the enactment of the law, non-consensual sex that happened before the enactment will not fall under the law. They will not have a retrospective effect. Ms. Elaine Chik, I'm not a member of this panel, so I thank you for allowing me to speak. I am glad that we finally see a comprehensive review of the laws on sexual offences in Hong Kong. I agree that the definition of consent should be revised and that the offence of rape should be broadened to protect children as well as people with mental impairment. I, in principle, support the proposed amendments. However, I have some concerns. I am particularly concerned about the recent increase in number of sexual abuses against children. There was a record high in 2025 as there were near 800 such cases. So this sparks concerns, and there are community groups that are concerned about children who are subject to prolonged or long-term sexual abuses. So my question is this. Will there be laws targeting offences of sexual abuse or offences of long-term sexual abuses against children? There are victims who are subject to mental torture because of the prolonged trial. Therefore, some community groups said this may deter victims from reporting the case or coming forward. So I want to know if you made reference to relevant practices in other jurisdictions. Are there such offences in other places? And will the penalty reflect the severity of long-term sexual abuses against children? Secretary. We noticed that in recent years, there are more cases of sexual abuses against children, and this is exactly why we're proposing the legislative amendment. The member asked about long-term sexual abuses against children, and I noticed that there are views in the community level that there should be a dedicated offense targeting long-term sexual abuses against children. From year 2000 to 2021, in relation to views concerning long-term sexual abuses against children, we had a discussion with the Bar Association as well as the Law Society. According to the views, of the two professional bodies, it's hard to convict the perpetrators because victims may not be able to recall the exact time and place where the crime happened. So there are also views that the current laws could deal with such a situation. Well, we will continue to monitor the discussions and see if our laws can deal with this. As to whether long-term abuse could be an aggravating factor for sentencing, say the court is aware that over the past 20 years, the victim is subject to sexual abuse by his family, and the sentence will definitely reflect the severity of the crime. Now, 18 members have spoken for the first round. 2 other members are waiting to speak for the first round. They are Dr. Johnny Ng and Mr. Perry Yu. Mr. Chang Hock Fong and Ms. Elizabeth Kwok would like to speak for the second round. If no other members are going to press the request to speak button, I'm going to draw a line here. Now, Dr. Johnny Ng, please. Thank you, Chairman. I support the direction as well as the measures proposed. I have a few questions. For those who incite children to commit sexual act using technology, how will you deal with such a situation? There are lawbreakers who make use of gaming platforms as well as social media platforms to lure children into harming themselves or providing their intimate pictures. I want to know if the administration have ways to deal with this. Secretary, we have proposed measures targeting this situation. For example, we are introducing a new offense of causing children below 16 years old to view images or send intimate images. And that's about disseminating or sending intimate images. Second, we are introducing an offense of sexual grooming. Say a pedophile asks a child out and sexually abuse that child, it would be a crime. Thirdly, we are introducing the offense of sexual assault without touching. As long as the perpetrator causes the victim humiliation, alarm, or distress, he would be caught by the law. As to whether the future laws will cover other indecent assault offenses or technology-related offenses, we will look into that. Mr. Perry Yu. The administration is proposing some legislative amendments, and the amendments will provide clearer definition of sexual offenses and provide stronger protection for vulnerable groups. And it is also to avoid discrimination against those with different sexual orientations. I support the direction. I hope that the proposed laws can be enacted as early as possible to create deterrence and provide protection. Now I'd like to ask about the extraterritorial effect of the proposed offenses. Say, 2 children are involved in a case and one sexually assault another outside Hong Kong. The police can still arrest the perpetrator and prosecute the perpetrator. However, if the case takes place in a jurisdiction with a different definition of the sexual offense, can the police in Hong Kong still arrest the perpetrator in question? To give you another example, a young person in Hong Kong gets sexually assaulted in a place outside Hong Kong. Can we invoke the laws in Hong Kong?
Yeah,
You mentioned 2 children being Hong Kong citizens and engaging in the act in another place. Of course, there's a lack of capacity to consent to such acts since they are minors below the age of 16. So we have jurisdiction over this crime and we can proceed. You mentioned another scenario, that is a Hong Kong citizen engaging in an act with a foreigner in another place. Is it against the law? I think we need to consider the two limbs. First, incitement and sexual assault. If it happens in Hong Kong, then we have jurisdiction. That is, we lure the child to go to, the perpetrator lures the child to go from Hong Kong to Thailand and engages in this act, then there is jurisdiction. Or if the sexual intercourse is committed unlawfully in Hong Kong, then we have jurisdiction. So in either case, we have jurisdiction over the crime. So if two young persons from Hong Kong go to another place, even if there's another set of laws in the other jurisdiction, we can still follow the Hong Kong laws. Even if there is no incitement involved, if the sexual assault takes place in another jurisdiction, then does the Hong Kong laws apply? Say for a Hong Kong citizen being lured to another country to engage in the sexual act there, then we may not have jurisdiction. Mr. Chan Hao-feng. I'd like to turn to page 12 of the consultation document. You propose to widen the scope of definition of rape, and that is penetration involving the use of genitals, and also penetrates the victim's mouth with his penis and causes the penetration with an object. And I understand that part about penetrating the mouth, but if it's an object, then does it constitute rape? Our position is that if it's penetrating the victim's mouth, it must be done with the penis, not other objects. Then it's kind of a sexual offense. It's a sexual offense, but not rape. That is, if the victim's mouth is penetrated with a penis or some kind of sexual assault involving touching, then definitely this threshold will be met. The last one to speak, Ms. Elizabeth Quat. Thank you, Chairman. For Area 5, I strongly support enhancing protection for victims of sexual offenses. Victims often face hardship. They face secondary harm at the stage of reporting the crime or giving evidence in court. For them to come out and report on such crimes, it takes great courage. We should protect them. Chairman, in this council, we've asked and urged the administration to allow victims to give evidence through CCTV in court. And I understand that in this proposal, victims will be allowed to give evidence via televised link. But recently, I noticed that there is this written judgment handed down by the judiciary. It's about the High Court turning down an application for the victim of rape to give evidence by televised link. Now, I understand that the court can exercise discretion. That means the judiciary can still have a chance to turn down this request. But now with legislative amendments, does it mean that there is no way the judiciary can turn down such a request for the victim of a sexual offense to give evidence by televised link? The legislative intent is to protect children, PMIs, and vulnerable groups. We can apply to the court for the use of these protective measures, such as allowing the victims to give evidence behind the screen or use CCTV instead of personal attendance in court. The cross-examination will also be restricted to not asking the victim about sexual experience with another person. Of course, we need to consider the fact that we should not prejudice the defendant. It's for the court to decide, but you can apply to the court. Well, but does it include PMIs, children? Children and PMIs are the major players in the vulnerable group. But of course, you may recall we have other special circumstances, such as the case of Ms. ABCD. In these special circumstances, application can always be made to the court. It's for the court to consider and grant this application. So much for this item. I thank Mr. B.K. Tang, Secretary, and his team to our meeting. We now move on to the next item. Item 4. Report on the work of the Customs and Excise Department as the Vice Chairperson for the Asia-Pacific region of the World Customs Organization. Let's invite the administration to come in.
唔該曬，局長。好啦，咁我哋咧就會歡迎啦香港海關關長陳子達先生啦，禁毒。
All right, welcome to our meeting. Let me welcome Mr. Chen Zidat, Commissioner of Customs and Excise, Ms. Zorina Wan, Commissioner for Narcotics Security Bureau, as well as a team to our meeting. I will invite the administration to make an introduction, and then I will open the floor for questions and answers. Now, we had a lengthy discussion just now. I'm going to extend the meeting by 15 minutes. Welcome, Commissioner.
好啦，如果有意發言嘅同事，而家可以撳掣嘅嚇。
Members, if you want to speak, please press the request to speak button. Commissioner, when you're ready. Mr. Chan. Chairman, I'm going to report on the work of the Customs and Excise Department as the Vice Chairperson for the Asia-Pacific region of World Customs Organization from July 2024 to June 2026, as well as its way forward in WCO. WCO is an independent intergovernmental organization. Under one country, two systems, the Customs and Excise Department, under the name of Hong Kong, China, has actively taken part in the work of the WCO. In the past 2 years, we have proactively taken up the role of facilitator and promoter. Between 2024 and 2026, the C&E Department has made a number of achievements. For example, we held 18 global and regional conferences, workshops, and programs so that the other delegations have a taste of our unique appeal, and this further enhances our reputation as the events capital of Asia. There are a number of highlight conferences. For example, in April 2025, the C&E Department and the Southeast Asian Nations Secretariat co-hosted the Conference on Simplification of Procedures and Best Practices for E-commerce, so as to foster a better collaboration between the customs and excise and also industry stakeholders. The joint statement was issued at the conclusion of the conference to reaffirm the commitment on enhancing collaboration among stakeholders to foster sustainable growth and development of e-commerce across the region. It forms a solid foundation. In March 2026, the C&E Department hosted the Regional Conference on Smart Customs. During the conference, booths were arranged for innovation and technology enterprises of Hong Kong and the mainland. to showcase the latest technologies to the international community, including AI, robotics, drones, blockchain, and big data-driven solutions, so as to enhance ties with global stakeholders in order to drive digital transformation of C&E services. And we also arranged for site visit or field visit to the custom facilities in Hong Kong, Zhuhai, and Macau for the overseas participants to personally experience the deep integration and unique advantages of the Greater Bay Area in modern logistics and technology application. It also showcases the success of One Country, Two Systems. Within the C&E department's term, we also facilitated the inclusion of 6 Hong Kong enterprises or organizations into the WCO Regional Private Sector Group, APAC, offering a direct platform for local businesses to participate in international trade policy discussions and providing them with more opportunities to explore global markets. We initiated Valid Debt. This is a trade document validation platform which makes use of blockchain technology. It provides instant validation of digital document certificates, licenses in a secure manner. In May, the CAD signed an MOU with the Pakistan Customs to expand the use of ValidDebt to Pakistan. We also launched the Youth Ambassadors Program, comprising over 100 local youths. We led them to take part in international events to enhance a sense of national identity and broaden their global horizons. Apart from serving as APVC, the C&E department was also elected as one of the APAC region representatives in the WCO Audit Committee. And we also was elected chair of this committee. It shows our professional competence and leadership role in the global arena. During the period that we have won the acclaim of the other regional members, and we have their support to continue as the APVC. With the support of the Central People's Government as well as support of the regional members, we have successfully been re-elected as APVC. The term of office will run until the 30th of June 2028. In this new term, the C&E department will continue to align with the National 15th Five-Year Plan. We'll leverage on our advantages and enhance ties with both mainland and the world so that we can showcase to the world the robust development in the Greater Bay Area. That's all for my work report. I welcome comments and views. Thank you. Thank you, Commissioner. 5 members have indicated they wish to speak, starting with Johnny Ng, Carmen Khan, Perry Yu, Thomas So, and Bill Tang. I've extended the meeting by 15 minutes, so I will give each member 4 minutes question and answer, please. Mr. Johnny Ng. I need to commend the work of the C&E department. I really appreciate your excellent work. And on the international stage, you'll definitely be able to showcase the appeal of Hong Kong. And I see that you have unanimous support for the re-election as vice chair. That shows that your work is widely recognized. And you're also chair of the audit committee of WCO. I really appreciate that. I have 2 questions. That's about resources. Now, since you are APVC of WCO and chair of audit committee, I want to know whether there are sufficient resources for the CNED to, say, make duty visits or receive overseas guests. The second question is this product, ValidDebt. It makes use of blockchain technology, and you signed a memorandum with the Pakistan Customs. My question about this platform is this. I suppose you will continue with your efforts. Are you going to include more functions on the platform? Are you going to promote this platform to other organizations to tell good stories of Hong Kong? Mr. Chan, Commissioner. First of all, I thank Mr. Ng for his recognition of the work of the CNED. About resources, between 2024 and 2026, the CNED sought funding approval from the Finance Committee of LegCo to create a time-limited supernumerary post of Assistant Commissioner of CNE, as well as one Assistant Superintendent. In the coming 2 years, as we continue to take up the Vice Chairmanship of WCO, we are we are fully aware of the fiscal position of the government. Now, we already have experience in organizing conferences, and we also learned a lot of skills and experience in the coming 2 years. As far as the Secretariat is concerned, we started with 13 in our establishment, but having regard to the experience acquired, we are going to reduce the post to just 7 in our establishment, having regard to our manpower situation, and that will have the establishment capable of meeting challenges. Mr. Ng also mentioned chairman of the audit committee. I will be taking up this position as well, and I am very happy to inform members that we have very young colleagues who are inspectors of CNE. They have joined the CNE department, and they are actually qualified chartered accountants. So we form a team. I'm confident that our staff will be capable of taking up the work in this regard. As for the progress, I will now give the floor to the Assistant Commissioner to take it.
I thank the member for the questions. Valid AP or valid debt makes use of blockchain technology. One of the greatest features is that the content of the trade documents will not be transmitted, but still, immediate authentication and certification could be carried out. This is because a password is given to a document, and the owner of the document can make use of our platform for quick certification. All along, we've been promoting this platform. We launched this platform in October last year. This March, this platform is connected with the single trade window. Some of the documents or certificates can now be certified on the Valid App platform. We launched this platform because there are many trade documents such as certificates of origin or certificates of hygiene. In May, we signed an MOU with Pakistan Customs, and we are in talks with a few countries. The Pakistani platform will be connected to the single trade window. We will continue to promote this platform at various levels to facilitate businesses in the region. This will benefit the economic development of the region. We have got a number of inquiries about joining this platform as well. Next, Ms. Carmen Khan. Thank you, Chairman. Last week, in FCR 2026-725, it is a document from the Finance Committee, and it said that the Assistant Commissioner post will be cancelled starting from the 1st of July. Just now, the Commissioner said the establishment will be reduced from 13 to 7. I think this is an important task. I hope that you will do your job well. While we want to save money, this is an important position of the CNED. So if you need extra resources, I hope that you will submit the relevant application. This is an important job because the CNED will help tell good stories of Hong Kong, and the CNED got an overwhelming support and an unanimous support for the re-election. Now, turning to the use of technology, I think we have to speed things up. You have been collaborating with the CEDB, such as on adopting blockchain technology to certify documents. However, our legislations governing e-trade documents are lagging behind. We have to catch up, so I hope that the CNED as well as the CEDB can speed up the use of technology. It is like the trade single window. We have the technology in place. However, we need to speed up the amendment of legislation. I want to hear from the Commissioner about this. Commissioner, I thank Ms. Carmen Khan for the recognition and for her understanding of the lack of manpower. It is true that starting from the 1st of July this year, the supernumerary assistant commissioner post was cancelled. My colleague next to me has been in charge of various types of work, and with the cancellation of the assistant commissioner post, he will take up a heavier workload. Of course, the more resources, the merrier for us. However, with limited resources available, the CNED will try its best to contribute to the SAR government. As mentioned, the CNED has accumulated considerable experiences in international events, and Mr. Lee, Assistant Commissioner, who's sitting right next to me, has gained a lot of experience as well. I hope he will be able to take up the heavier workload in the coming 2 years. Indeed, as we organize large-scale international events, we do not only rely on the 7 staff in the Secretariat. We deployed other staff to help host large-scale events. So I'd like to take this opportunity to thank my team for their hard work over the past 2 years. In times of major events, our colleagues have worked together over the past 2 years. While the Secretariat will see the establishment reduced from 13 to 7, I'm confident that we'll be able to handle the work. As for hosting large-scale events, we will deploy staff temporarily to join us. Ms. Carmen Khan mentioned ValidDAP. I'd like to supplement here. This is a trade document validation platform, and this platform helps address the pain point that we encounter as we share trade documents with other places. We need certification as we share documents with other jurisdictions. However, various jurisdictions have identified challenges in the process. The ValidDAP platform does not require any exchange of digital or electronic data. And this helps do away with the legislative amendment required for such certification process on e-platform. More members have been supporting this ValidDAP platform. As for trade single window, starting from this May, we have already opened up the channels for exchanging or sharing 6 different types of documents. Moving forward, we hope that the trade single window in Hong Kong can be connected to the trade single windows in our country as well as countries in Southeast Asia. We hope that this can enhance convenience for the relevant sectors. This can also help the CNED conduct back-end analysis against high-risk cargo. Next, Mr. Perry Yu. First, I would like to congratulate the CNED for being re-elected as the Vice Chairperson of the Asia-Pacific region of the WCO. Over the past 2 years, the CNED in its term has been acting as a promoter and facilitator. It has given full play to our strengths, and it works as a two-way platform for bringing in investment as well as helping enterprises go global. I would say that the CNED has achieved a lot over the past 2 years. I am also aware that the CNED has rolled out the Youth Ambassador Scheme, and this helps broaden young people's horizon and cultivate their sense of national identity. I see that over the past 2 years, the CNED has successfully organized 18 international conferences, workshops, as well as capacity building programs. Well, 18 is not a small number. While having organized these international events, the CNED also took the opportunity to promote the culinary delights in Hong Kong. I want to know if the CNED has kept this information. How many high-end visitors have you been able to attract to come to Hong Kong through the 18 global and regional events, and how does this benefit the hotels and tourism industry in Hong Kong? These international events are great because they can help promote economic growth in Hong Kong. They bring both tangible as well as intangible benefits to the city. So I want to know if you have kept the statistics showing how many visitors you've been able to attract to Hong Kong through these events. Also, I hope that as you have been re-elected in the coming 2 years, you can continue to tell good stories of Hong Kong. Mr. Chen, I thank Mr. Perry Yu for his recognition of our work. Mr. Perry Yu asked how many overseas visitors were brought to Hong Kong through the 18 global and regional events. We invited senior management as well as leaders and experts from 34 member states of the WCO. In total, we managed to attract 1,379 overseas delegates as well as members of overseas customs authorities to Hong Kong. As Mr. Perry Yu said, in the coming 2 years, we will seize every opportunity we have to tell good stories of Hong Kong. We will showcase Hong Kong as an events capital of Asia, as well as a capital of hospitality. We will also bring overseas delegates as well as participants to neighboring cities. For example, in the Smart Customs Summit this March, we brought overseas delegates to the Hong Kong-Zhuhai-Macau Bridge. We also brought them to the customs facilities in Macau and Zhuhai. We brought them on a one-day trip, and we were able to showcase to them the success of one country, two systems, and the deep integration of the Greater Bay Area. And this is even more compelling for them compared to the good stories we tell. Also, Mr. Perry Yu mentioned the Youth Ambassador schemes we launched. Secondary school as well as university students were able to receive guests in international events we host. They even served as MCs in these events, and these events help them broaden their horizons, and this is very helpful for their future development as well as personal development, and we will carry on with this effort in the future.
Dr. Thomas So. First of all, I acknowledge the work of the Customs and Excise Department in the past 2 years, and I would like to congratulate you for being re-elected again. My question is about valid debt. This is a trade document validation platform, and this is an official platform. So for G2G, I think that you're excelling. You've signed an MOU with the Pakistan Customs, and I hope to see more successful cases in the future, because this is the product of R&D in Hong Kong, and that we're able to reach a certain standards, and that's the official standards. As I understand, the market has begun to digitalize trade documents such as bill of lading, bill of exchange as well, and that we need to form the basis of certification to verify that this is the authentic signed document. I know that this system is developed by the government, but my question is on the backbone of this system. As I understand, there are private platforms doing the same validation process too. So my first question is whether you can make reference to the platforms so that we can raise the standard and that we'll be able to meet the global standards in the future. The second question is about Mr. Perrier's previous point. That is whether you'll be able to receive income through transformation. Now my question is this. The CNED has achieved success in gathering intelligence and exchange of information. Now that you've had so many conferences and exchange sessions, is there anything that can help boost the law enforcement capacity in Hong Kong? I'll answer the second question, and for the first question about valid debt, I will give the floor to Assistant Commissioner Mr. Lee. About our achievements, as Vice Chair of the WOC Asia Pacific region, we foster collaboration among the customs in the region. We have obtained numerous achievements in safeguarding national security, in stopping contrabands from coming into Hong Kong. The Customs and Excise Department cannot work on its own. Cargoes move freely among countries. So we rely on close collaboration and exchange of intelligence with other customs organizations in the region to stop contrabands. Let me give you an example. Last year, we provided information to we were given intelligence by the Singaporean authority, and then we were able to intercept 33 container terminals worth of illicit cigarettes. As for Australia, they have a higher tobacco duty, and we offer intelligence to our counterparts so that they're able to capture smugglers. On combating narcotics and copyright infringement articles, we work with other members of the WCO in a very close manner so as to lower the cost of law enforcement. We also provide facilitation measures for law-abiding businessmen in dispatching cross-boundary consignments. So this is for the benefit of the whole society. Mr. Lee can take the question on valid debt. Thank you, Chair. About valid AP, this is wholly designed and developed by the CNE department. We have we have the unit supporting us for implementation. And that this is on the government cloud, is overseen by the Digital Policy Office. We abide by the highest standards in terms of security and technical requirements. There is no need to have any exchange of data. This is the biggest feature. So the major difference between the Hong Kong platform and the overseas platform is, like the member said, about bill of lading. It provides support to different procedures such as PCS, the Port Community System. We maintain very close partnership with the development team of PCS. No login is required. In Singapore, they have a similar platform, but logging in is required, or the use of an e-certificate is required. For our valid app, our design is that as long as you have the e-documents, there is no need to log in to any account for verification. Many overseas government organizations are very interested in our system. There are different application scenarios, such as graduation certificates. And we'd like to promote its use to other departments or other countries. And this is something we'll continue to do. Thank you. Mr. Bill Tang will be the last one to speak. Does anyone wish to speak again? If not, then Mr. Bill Tang. Thank you. I thank the CNE department for its hard work in participating in international affairs. I congratulate the department for being re-elected as the law enforcement agency. I like to commend your work because you have to serve 3 policy bureaus. You need to take law enforcement action against smugglers and drug peddlers, and you also need to tackle money laundering on the financial front. On consumer protection, we're now proceeding with a proposal to set up a cooling off period. So there is a lot on your plate. With the existing establishment, it's really not easy to cope. My question is this. We go by one country, 2 systems, and it's our tradition to be the connector. Now, for the Customs and Excise Department, we need to tell good stories of Hong Kong. We need to explain our merits to others. But in the Greater Bay Area, we need to take forward integrated development as well, so as to foster collaboration with neighboring cities in Guangdong province. At the same time, we face the world. We must let others know that we have one country, 2 systems. It's different from other cities in the mainland. We need to tell others our unique strength and that we are a free port in order to give play to our role as a super connector. So can you share your insight with us? The second point is about narcotics. In terms of international affairs, this is a hot button issue. So can you share with us your achievements in fighting narcotics in these international conferences? Mr. Chen. On international affairs, the CNE department has invited overseas guests to take part in various international conferences in Hong Kong. I think this is the best way for them to take a close look at the success of one country, 2 systems here. As the member mentioned, Hong Kong is a separate customs region as spelled out in the basic law. And in the capacity of Hong Kong, China, we are a member of the WCO because of our separate customs region. We're one of the freest economies in the world. So we're setting a very good example in terms of customs control to the world. At the border checkpoints, we adopt the most relaxed approach to facilitate businesses and logistics arrangements. We win the acclaim of the international community, especially customs organization. So through these international conferences, we tell the good stories of Hong Kong loud and proud. We have a transparent system, and we have a clean system. We have efficient management. Many global traders are willing to invest in Hong Kong and do business here and raise funds here. This is exactly the role played by Hong Kong. In this process, we also enhance connectivity with the mainland and with the world. For example, in the international conferences, we led the representatives to Macau and to the mainland to visit these places and observe the advanced technologies. As for controlling contrabands, we have a mutual assistance mechanism. We work closely with our counterparts, including ones in the mainland and other places. We provide intelligence to each other in a seamless manner. We may not have a big establishment, but we're able to detect contrabands at the front line and stop them from coming into Hong Kong, so as to safeguard people's well-being and safeguard law and order here. With limited resources, we have been able to achieve a lot. This is also due to the hard work of our team, as well as support from other customs organizations. As for narcotics, I'll give the floor to my colleague. Well, before you speak, we're supposed to wrap up this meeting in 3.5 minutes. So let's see if members agree. I will extend the meeting by another 10 minutes so that Ms. Wan, Commissioner for Narcotics, can also speak. Thank you, Chair. Thank you, member, for the questions. There is no border when it comes to narcotics. The Security Bureau has resorted to different means to tackle narcotics. We take a 5-pronged approach. Apart from prevention, publicity, R&D, rehabilitation, and treatment, as the member just now mentioned, it is very important to collaborate with external parties. And that is why the government has been working with international and regional counterparts on combating drugs. Last year, under the in the capacity of the Hong Kong-China delegation, our government attended the UN Narcotic Committee's annual conference. We received recommendations of the WHO and the UN on new types of dangerous drugs so that we can proceed to legislation as a next step. And this is also closely related to the work of C&E department as well. The police and the C&E department communicate with mainland and overseas collaborating partners. There are also regional international organizations in close liaison with us. So we set up an extensive network for intelligence sharing. And we also share intelligence and information about the latest trend of addiction or drugs, so that we share intelligence and combat narcotics together. Anything to add from Mr. Chan? If not, then that's the end of this item. Thank you, Mr. Chan and your team. Next item, AOB. Nothing under AOB. So the meeting's adjourned. Thank you.